Here you have a couple of photos I was sent this morning. So this is going on today. This is very much ongoing. Most of this takes place in the form of civil disobedience, where activists physically stop machines, sit on them, try to block roads, those sorts of peaceful actions that are illegal, they are disruptive, but it's happening in as peaceful of a manner as possible. The response from mostly police is what we'll be talking about. It happens in the form of physically removing activists and issuing quite large fines. And what I'll be arguing is that these sort of legal measures in the form of big fines is the preferred way for the police to crack down on civil disobedience in Norway. The police, of course, stress that this is happening, or we're stopping a legal project. It's ignoring the fact that the company has been caught in doing illegal construction twice, both in 2021 and in the start of our action. We discovered that they were building a tunnel that they weren't allowed to. And also mentioned that this is the first time where reindeer herders in Norway participate in civil disobedience in their own area. Or it might have happened during the Alta protests in the 70s, but it's at the very least the first time in 40, almost 50 years. So this is quite a serious and polarized topic. Also, the reindeers are taking part of it, so that's kind of fun. I'll try to tell the story of Basil, which is an American activist who came to join us. Had quite a culture shock when she arrived, seeing that the police are using these carrying sails to peacefully remove activists. They're being very careful to not destroy clothes or using violence in any way. Quite the shock for an American activist who are used to police violence almost every week, but soon discovered that the punishment can be just as harsh here regardless. They're an American citizen but have Swedish grandparents who live in Sweden right now, and after taking part in these actions, she was deported from all of the Schengen area for quite, I don't remember how many years, but quite a lot, and will then not be able to visit family for almost a decade. So this is sort of a way of using the law to crack down on activism that people might not be expecting to happen here. This is also just one of the reindeer herders, Nils Mattis, holding a reindeer skull that we discovered that had been hung up above the entrance to the mine, spray painted orange by the construction workers. To me, there's also one more fact that sort of proves that the law is being used to actively discourage activism, and that's the fact that the fines being issued here have been doubling over the summer. So for someone joining for the first time in June, they would receive a fine of 800 euros approximately, but if they arrived now in August, they would get 1,500 euros instead. So it's also quite expensive for 16-year-olds doing this for the first time in their lives and breaking the law for the first time in their lives. The second case is the Fosen case that Eivind mentioned earlier, Esmeralda talked about. It was a protest against a wind project being constructed before a Supreme Court ruling. That Supreme Court ruling in itself is an exception to how the law usually works for indigenous communities. It was essentially the first time that Sami people won in the Supreme Court. This is taken on Fosen with some of my fellow activists. We occupied the Ministry of Oil and Petroleum in 2023, 500 days after winning in the Supreme Court, where nothing had been done to implement the decision and the land was still essentially stolen. We had support from pretty much the entire public sphere, especially from the legal sector, and legal professionals. It was a petition from law students being signed by more than 1,000 current students, law professors being very outspoken. We have got a letter from the Judges Association essentially arguing the same thing to me that we were, and that letter was sent to the Prime Minister. So kind of the most popular civil disobedience action can be. When we came to the Supreme Court, still it wasn't the fact that we tried to enforce the rule of law and democratic principles that made us, that it ended up being the reason for us being acquitted. It was just the fact that the police abused their powers in depriving liberty for about 1.5 hours. So it wasn't that civil disobedience is an important democratic safeguard. It was just the fact that police went one step further than they probably should have. I'm probably done on time.
Yes, no,
Yeah.
that was super interesting, so thank you very much. So I was thinking, what do you say, Runa? How does this reconcile with the rule of law, right? Because that's one of your topics. What's your take on slabs?
Right. Well, I would like to jump into talking about it from a very different angle, to be honest. But this is a super great transition, and I'm really grateful to have got to hear about your experiences with it very live. And I'm thinking I need to get out of the library more. But so I'd like to be honest, the strategic litigation is not so much my area per se. I learned a lot about this from the last panel, but I'd like to kind of contribute a different view as a jurist and try to sort of propose a step back from thinking about strategic litigation to first ask, essentially, do we actually have a legal right to protest? So what we know from listening to accounts like the one you just told is, in terms of how the right is actually effectively implemented and enjoyed, it's really sort of on shaky grounds these days, and we see this a lot in the news and in different stories. And there's more and more great literature coming out of spaces, as in academic literature, out of spaces like these about the uses of lawfare and not just political, but legal means of repressing the right to protest. So we know the right is not super effective at the moment, but also does it actually exist per se? And I know this sounds like a really strange question because we're talking about the right to protest all the time these days. But in fact, we don't have an express right to protest under international human rights law, and it's also the case in a lot of domestic constitutions. It's sort of pieced together from the rights to freedom of expression, assembly, and association. And most jurists kind of don't question this setup. So one thing that I want to try and propose to do with my doctoral research is to ask, is there something inherent in this form of the right that makes it so vulnerable to attack? Like what is it that's at the root of legal protections for the right to protest that allows the law to kind of turn in on itself and also attack this right that's supposedly democratic and crucial? And I find there's already some kind of quite immediate legal issues with the phenomenon of this fragmentation of the right. So each of these rights to expression, assembly, association, they serve much broader purposes in reality. So they protect like wedding processions and fans of football crowds in quite a similar way to how they protect protests. There's not really any advanced special recognition for the fact that this is serving a more important legal and democratic goal and has a higher value than that. The rights are invoked in a very kind of unsystematic way in legal judgments, and even where they are invoked together, the legal frameworks really encourage protests to be divided up so that we look at the content and the form of them separately, and even within that they're quite segmented. And I think that this makes regulators quite blind to what protesters are essentially trying to achieve. This is why it's nice for me to be around people like yourselves who look into protest strategies and objectives and opportunity structures, whereas typically regulators are looking at, okay, can we just move the protest somewhere else at a different time, or can they not do a protest and just write to their MP instead, for example? So overall, this results in a really messy and unpredictable body of case law that really doesn't create more stability for protesters. They're already subjected to not just a kind of growing body of legislation on protests that's being really weaponized, and the case law in the way that I just described, but also an increasing kind of abusive use of administrative decisions, and then also police action. And unfortunately, international human rights law has very little effective purchase on how all of those bodies of regulation impact them. So this is quite demotivating for protesters that are actually trying to, in some ways, abide by the law in their protest and to engage constructively with it in a certain sense. So concretely, like, what can we try and do to make the right to protest more secure from within? And I think obviously, like, one obvious solution would be to try and argue for a more unified or express right. But I think before that, we need to consider, like, what purpose should actually drive the regulation of protests, and how can protests be understood in a new legal light, in a sense. We of course know that protests have always played this fundamental role in contributing to the creation of law, but typically through them protesting, being arrested, and then some legal change happens, and then retroactively we forgive them, but there's no immediate recognition of their role. But so another thing that my thesis ambitiously tries to do is to ask, what if we were to understand protests as interpreting and shaping the law even outside of courts and these traditional legal mechanisms? So protests as a site of law in and of themselves. I think this is particularly important for, I think you know about more about this than me, but this is particularly important for indigenous movements. So the UN Declaration on the Rights of Indigenous Peoples recognizes their right to self-governance, and specifically their right to develop and maintain their own legal systems or justice systems. And I think protests can offer a really interesting and important liminal space between state justice and indigenous justice, where protesters can draw on state law and international law and how they formulate their claims, but also concepts from indigenous law and their own systems and cultures and their own languages and forms of expression, and they can do so on their own terms in a way where courts, even though in some cases they have been used very effectively by indigenous people, can also offer kind of a subjugated space. But this offers a much more liberating space for them to advance the claims in the way that they choose to do so. So I think we ought to work towards thinking about this freestanding value, legal value of protest, not just as a way of kind of reimagining what the law could look like, but also kind of collectively in some examples, like modeling and enacting what new forms of governance could look like. So I think when we think about SLAPs and strategic litigation against the right to protest, the goal should be to try and grant more legitimacy to protest as a source of law in and of itself, especially at a time when courts and our democratic institutions are being vulnerable to capture.
Thank you very much. Pulling the threads, I see an interesting argument going through what Rasmus and Runa have been telling us. So Rasmus was acquitted not really for the right to protest, but for misconduct by the police. And Runa is telling us there is no structured way to approach the right to protest. And why isn't it so? Is it because it's not very common to see it enshrined in constitutions, for example? I remember back from my law school days that the German constitution is really one of the few protecting the right of resistance. Article 20, it's a principle. So this, of course, comes from Germans' history of Nazism, from the philosophy of Hannah Arendt. But would it be a way for legal cultures, legislation to enshrine the right to protest in higher sources of law to make it happen, actually? And what's actually the take we can have also on the European legal culture? Does it allow for the right to protest? We are going to have also an anti-SLAPP directive to be implemented by next year. So what's happening in Europe, Mikael? Would you like to have a take on this?
Yeah, thank you very much. It's always a delight to be in Bergen. My hair is bursting with thoughts and ideas. But let me maybe go to the more cultural underpinning, political and cultural underpinning of the type of phenomena that we are observing. Ramas said about this change from what I called in my notes, from the arrest to deportation, basically as a tool of dealing with protest. And Rona indicated that much of the efforts and thoughts of the authorities goes to the moving of protest. And I think there's a certain shift that it's going on. So we can place the problem of slabs and restricting protest somehow more broader theoretical perspective and framework. John Keane, in Australian political theorist, in his books from 2020, The New Despotism, argues that the 21st century autocracies differ from their 20th century counterparts in that they are primarily aimed at demobilization, not mobilization. As the old autocracies relied on mass rallies, compulsory participation, ideological indoctrination, that this new wave of autocracies, and if you believe the VDEM reports, this is the most common global transitional process around the world. So these new autocracies depend more on the political passivity, social fatigue, and the normalization of civic withdrawal. So now we can ask questions, so how do you do it using legal tools? And I would argue that you do it by changing the legal apparatus from aimed at the using criminal law to using administrative law and with some kind of help of constitutional law. Let me give you some examples here. In 2070, Poland Constitutional Court made a decision on the right to assembly, where the Constitutional Court upheld the changes that restricted spontaneous and counter demonstration, and they privileged so-called new type of cyclical assemblies. This new type of assemblies got the priority of organizing protest in a certain space. So it was some kind of parcellation of public space and giving the priority to certain type of demonstration that were connected with somehow with the Polish culture and the Polish national identity. The problem is that who decides whether the assembly is connected with those good values, it seems? The administrative authorities, so the government itself at the end. My second example comes from the Netherlands, where we see now a wave of ban on access to the Schiphol airport after 2020 protest on the Schiphol airport, organized by Extinction Rebellion and the Greenpeace. Protesters now get 5 to 10 years ban on physical access to the facilities of the airport from the airport itself, which has the form of this public limited liability company. So who decides now on the reasons of the granting this kind of ban? The authorities themselves. The examples could go on. Let's just mention only the Garcia Abrego case from the US, who was deported from the US soil, even having the right to be there, in what the Trump administration called the administrative error. So what makes the administrative law such a handy tool for using it to demobilize citizens and switch off certain type of rights that would be ascribed in the... So there are three things. First is that administrative law is based on the presumption of legality of administrative acts. The second is this privilege of execution of other administrations. Once the decision is issued, the same entity executes the decision. And also administration and administrative law has this discretion and the fact-finding. In the typical criminal proceeding, you have the prosecutor's office that builds the case, collects the evidence, and then you have independent court. In administrative procedures, the one who finds the facts and frames the case and also issues the decision is the same body. So those features result that even if you have a judicial overview of those administrative decisions, it's done way after the decision was put into effect. That is why it makes it such a handy tool for this wave of autocratization. And you can do it, that's why it's autocratization. I like to use it not as a noun, but more as a verb or some kind of process that is happening, because you can at the same time, from the point of view of authorities, underline the importance of the right to protest of democracy, but have this administrative but. right to protest is very important, but you have to do it in a certain way, and if you don't abide to it, then we have a certain right to do things with you that are not criminal, so they are seen as lesser involvement with the constitutional rights. But from the point of view of influencing social behavior, they're even more effective than the typical criminal law, I would say. So taking together these examples, this reflection showed us restricting public participation and strictly rely on legalistic and technocratic instruments of control rather than direct repression, thereby embedding this demobilization with the some kind of rule of law facade itself. And that, of course, doesn't mean that we have some kind of replacement of this direct physical violence. I would rather argue that we have a new layer that is built above this direct physical policing that makes this kind of policing even more effective. And it's hard to tackle from the point of view of the law itself. So if you will go on the conferences of administrative lawyer, I'm afraid that you will not find much of intervention tackling this autocratization and using administrative law for autocratic needs, which is alarming in itself. Thank you.
Thank you. Thank you, Michael. Sophia, you've been researching a lot on repression. What's your main finding? What would be your understanding of what's going on in SLAPs and the right to protest?
Perfect. Thank you so much, Esmeralda, and thank you for everyone. It's a pleasure to be here. I'd like just to begin by highlighting that when we talk about SLAPs or legal repression against activists in the Brazilian context, we're very much talking about criminal action. So defamation lawsuits in Brazil are a specific kind of criminal action that can be initiated by private actors, as are several other legal claims that in many other countries would be restricted to the civil sphere. So, of course, the threat that these actions pose are very high and illustrate the extensive reach of our criminal justice system. And these are private actors that are often operating in a way that is deeply embedded within the state, in a strong partnership within this, with the state, as is the case, for instance, of mining companies. We heard a little bit about Belusan in a previous panel. And when they act as these enforcers of law and order, as had been mentioned, they do so enabled by the state. And what I mean by this is when the Brazilian government chooses to ignore the fact that there is a mining company engaging in private criminal action against the indigenous population, journalists and researchers, that is also a way for the Brazilian state to outsource the repression that itself wants to enact, right? Because these mobilizations are against a project that has been, fostered and authorized by the Brazilian government. So by doing so through this powerful private actor, that is a way of shielding itself from the political backlash that would ensue if the state was the one publicly leading this repression. But however, in cases of mass protests in areas with more visibility, the state is often the main repressive actor. So I'd just like to share very briefly some of the findings of a comparative research that I have been involved in on protest cycles that happens in Brazil in 2013, in Nicaragua in 2018, and in Chile in 2019. So in all of these three cases, the state's first response was very focused on police presence at the moment of the protest events. But because police action was so violent, it generated a really strong backlash and had the unintended side effect of strengthening mobilization, bringing more people to the streets. So that's when legal repression comes in, but that's like very clearly at a second stage after the peak of the protests. And then it really did succeed in these three cases in creating a chilling effect. And of course, many of these criminal lawsuits lasted many years, and even if they did not end in a conviction, which as we know is not their main goal, this lengthy process was enough to severely undermine several social movements in the region. I'd just like to highlight some of the main characteristics of this legal repression. So number one, it's not just that the criminal actions are vague, is that they're purposely confusing. So they lump together as co-defendants a bunch of people that have nothing to do with each other, from organizations that sometimes hate themselves, people who met each other in the courtroom. It's not clear what the charges are. It's not clear what are the facts that are being discussed and criminalized. And in the investigation and the criminal lawsuits itself, the police and the prosecutors present a really unstructured, unsystematic narrative of what is going on. And that by itself, it just makes it so much harder to talk about these cases, to narrate these cases, because it's so confusing. You need to make so many caveats, it's difficult to explain. And that is very clearly very much a choice, right? Second point, well, legal arguments aside, the interpretative framings that are produced by the police officers and by the prosecutors are very relevant in disputing not only the opinion of the judge, but also the media and public opinion at large, right? And then here, there are a few enemy framings that are mobilized very intensely and that I think are interesting for us to look at. So we often see, I think this is a very Latin American thing, but we often see these repressive actors producing these really far-fetched links to drug trafficking. So not as the official criminal charges, but just like randomly talking about the dangers and the harms caused by the narcos and the traficantes in the middle of this discussion about the protests and the activists, right? Without ever explaining like what that connection would be, but still like including that element in there somehow. So if you're not paying attention, you assume that, you know, it's somehow relevant, but it's really not. They're just like creating that weird connection. So that's an internal enemy framing, which is very effective in the region. But we also see external enemy framing. So for instance, in Nicaragua, there the government had a super authoritarian response, a regime change really, and the government was left-wing. So in Nicaragua, this took the form of accusing the protesters to be led, to having links to the CIA, to the United States, to the Yankees, so that kind of framing. And in Chile, where the government was right-wing, Sebastián Piñera would say very openly that it was Venezuelan infiltrators with guerrilla training who were behind the protests. And in the Brazilian case, well, we get them both because we had a left-wing government, but the protests were also left-wing, at least a large portion of them were further left than the government. So we got, on the one hand, the police accusing the demonstrators of having received guerrilla training in Cuba and in Russia, and on the other hand, the government indirectly, not so blatantly, but indirectly blaming the CIA and USA intervention for the protests. Third point, all of these legal actions, they are justifying themselves as something necessary for the protection of democracy. So it's not just that they're mobilizing rights language, but they're specifically mobilizing defense of democracy framings. And this is done, and this is relates to one of Michael's points, this is done, for instance, by talking very extensively about the importance of the right to protest, the importance of free expression, only to say, after, 5 pages of legal discussion on this, that, in this specific case, it does not apply. But it's not that we don't believe in it. It's just that, like, here, that's not the case, right? And then just a final point. In these criminal lawsuits, there is very clearly an assumption of legitimacy in everything that the police does. And in Brazil, this is actually this assumption of legality for what police officers do. It's a legal construct that was borrowed from administrative law, but it's unrelated because in administrative law, it serves a purpose. In criminal law, why would you assume that, a police officer giving a statement that's inherently true, right? But sometimes we do have cases where it's like really obvious, and all of the social media documentation that you can possibly think of, it's very obvious that the protest was super peaceful and still we had a very violent police response. This is Latin America, so violent police response is live ammunition, is assault rifles, right? And the technique that is then used by these criminal justice actors is to produce a framing of what happened in a way that leaves any use of force by the police completely out of the picture and only talks about the things that the demonstrators did, even if that is the usage of protection goggles and carrying like makeshift shields and handkerchiefs with vinegar, which everyone knows is used for, the tear gas. So they reframe these like fundamentally defensive objects as if they were weapons being used against the police, and then you just can't win. So that's it.
Thank you. Yes. So let's open the floor to questions. Fantastic questions. Thank you so much. Just come to the speakers to ask. I realize that you already have a speaker to ask the questions to.
Yes.